6301. Okay, so this question says, which, if any, of the following are true concerning a preliminary injunction? 1, may be granted ex parte. No, that's wrong. Has to be on notice. Preliminary injunction is always on notice. 2, it must appear that immediate and irreparable injury, loss, or damage will result unless defendant is restrained before a hearing can be had. And that would be true if it was a TRO. Now, in the question it says or, but I'm reading that as an and because I have so much trouble remembering that it is an and. 3, unless the court orders otherwise, a motion for a preliminary injunction along with the papers upon which it was based and a notice of hearing for the preliminary injunction shall be personally served in the same manner as a summons. That's also wrong because that is the language they're using for a TRO. 4, prior to the granting of a preliminary injunction, court may require plaintiff to give an undertaking in amount fixed by court. Now, that is false. Because a plaintiff shall give an undertaking prior to the granting of a preliminary injunction, and I believe in the attachment one, the order for attachment. So for order of attachment and preliminary injunction, the plaintiff shall give an undertaking. And so for order of attachment, I actually got a monetary minimum on there. I think it says it has to be $500. CPLR 8007. This is question 42. Except where otherwise prescribed by law, the proprietor of a newspaper is entitled for publishing a summons, notice, order, or other advertisement required to be published by law, order of any court, or the clerk of a court, to a fee of between 29 cents and up, depending on the newspaper circulation. So fee per line of a column width not less than 10 pica EMS, provided that in computing such charge per line, the line shall average at least 5 words per line. Question 43, 8011. A sheriff shall be entitled to a fee of $15 for serving an income execution, entering it in the appropriate books, and return when required in advance. So you have to pay the sheriff in advance. Question 44, CPLR 8012. A sheriff is entitled to the current federal IRS mileage reimbursement rate for each mile necessarily traveled in performing which, if any, of the following services, payable in advance. 1, serving or executing a mandate upon or against one person, or upon or against 2 or more persons in the course of one journey, computed from the nearest office of the sheriff in the county to the place of service or execution, and return. 2, serving or executing 2 or more mandates in one action upon or against one person at one time, computed from the nearest office of the sheriff in the county to the place of service or execution, and return. 3, attending a, quote, view, computed from the nearest office of the sheriff in the county to the place of attendance, and return. Okay, then 4 is, I don't even know where that came from, but couldn't find it in the statute, so that's a no. 5, serving an order of protection. There is no fee allowed for serving an order of protection. Sheriff does not get a fee for that. Question 45, 8009. Any authorized officer is entitled to a fee of $2 for administering an oath or affirmation and certifying it when required, except where another fee is authorized by law. Question 46, CPLR 7501. Which, if any, are true concerning the enforcement of a written agreement to submit any controversy to arbitration? 1, it may apply to an existing controversy or one thereafter arising. That's true. So that means it can apply to an existing controversy or one that's going to arise in the future. 2, it is enforceable without regard to the justiciable character of the controversy. 3, it confers jurisdiction on the courts of the state to enforce it. 4, the court shall not consider whether the claim with respect to arbitration sought is tenable or otherwise pass upon the merits of the dispute. All correct. justiciable character of the controversy. I think that means, like, could you actually, have a civil action on it? Question 47. Which of the following is false concerning arbitration? A. A special proceeding is required to bring before the court the first application arising out of an arbitratable controversy which is not made by motion in a pending action. Well, that one is true. You have to do a special proceeding for the first application unless there's already a pending action going on when an arbitratable issue arose. B. The proceeding shall be brought in the court and county specified in the arbitration agreement. That's also true. C. If no county is specified in the agreement, the proceeding may be brought in a county where the party seeking arbitration resides or is doing business. After it begins, can be where arbitration is being held. D. The Supreme Court in a county in which an arbitration is pending may, under certain circumstances, entertain an application for an order of attachment or a preliminary injunction. So it's where the arbitration is pending or where it could be commenced either inside or outside the state. And that's also true. E. If an arbitration is not commenced within 30 days, that's how you make it correct, 30 days of the granting of provisional relief, the order granting the relief shall expire, be null and void, and costs may be awarded to respondent unless the court has reduced or expanded this period for good cause shown. An arbitrator and any attorney of record in the arbitration proceeding has the power to issue subpoenas, and only the arbitrator can administer oaths. 7510. This is also question 6. The court shall confirm an arbitration award of a party made within 1 year after its delivery to him, unless the award is vacated or modified upon a ground specified in 7511. 7503 sub C. Which of the following is false? A party may serve upon another party a demand for arbitration or a notice to arbitrate specifying A. The agreement pursuant to which arbitration is sought. That's true. B. The name and address of the party serving the notice. That's also true. C. That unless the party served applies to stay the arbitration within 20 days after such service, he thereafter shall be precluded from objecting that a valid agreement was not made or not been complied with, and from asserting in court that the claim sought to be arbitrated is barred by limitation of time. D. Such notice or demand shall be served in the same manner as a summons, and that's false because it can also be by registered or certified mail, return receipt requested. Okay. CPLR 6219. Within 10 days after service upon a garnishee of an order of attachment, or within such shorter time as court may direct, the garnishee shall serve upon the sheriff a statement specifying 1. All debts of the garnishee due to the defendant. 2. When the debts of the garnishee are due to the defendant. 3. All property in the possession of the garnishee in which defendant has an interest. 4. The amounts and value of the debts and property. 5. If the garnishee has money belonging to or is indebted to the defendant in at least the amount of the attachment, he may limit his statement to that fact. So those are all true. 52. Kelly obtains an arbitration award against Anne. Anne participated in the arbitration. Anne is unhappy with the award. In which of the following scenarios could Anne prevail on a timely application to vacate the award? A. The court finds a valid agreement to arbitrate was never made. That was waived because Anne participated in the arbitration. B. The court finds that Anne's rights were prejudiced by a fraud perpetrated by Kelly in order to obtain the award. C. The court finds that Anne's rights were prejudiced by partiality of an arbitrator who was appointed as a neutral, and the award was by confession. This would have been true if the award was not by confession. D. The court finds that the agreement to arbitrate was not complied with, and that is waived.